We're live. Hello, fabulous people. Good morning to you guys. Happy Friday. Happy Friday to everyone. I hope you guys are doing good as I am. I'm doing great. Join in. Today we have a lot to talk about. We have two whole new topics to talk about, and I'm very, very glad to be here. Oh my goodness. So guys, drop me your comments, like the page, subscribe please to the channel if you're watching on YouTube. And if you watch this video later, of course, don't forget to like, comment, subscribe, and you're welcome to this video. So today we're going to be discussing two things. The first thing is we're going to be discussing the new medical rule for getting a green card. And then secondly, a COVID update that is related to travel. Okay, this is brand new, sparking new news. So please stick with me and let's have some legal fun. Guys, drop me your comments. Let me know where you're watching from. As usual, I'm recording from the marvelous city of Manassas, Virginia. We're based in Northern Virginia. That's where the law office is based. So that's where I'm recording from this morning. Okay, so let's jump into it and stop all the ratatata. Okay, so there's been a temporary waiver of the 60-day rule for medical and examination vaccine records. So let me pull this up, guys. Hold on. Oh no, I think I made it go away. But normally, if you want a green card, okay, you are supposed to, when you're filing an adjustment of status application, you're supposed to include in the adjustment of status application a medical record of your vaccination records or just a medical record. So there are designated medical doctors or civil surgeons that are responsible. You inadmissible. So one major requirement for becoming a green card holder is that you are not inadmissible, and being inadmissible could be as a reason of health, could be based on health grounds. So in the recent past, having HIV/AIDS made you inadmissible to the United States, but that has been waived. But currently there are still some if you have certain diseases, you will be inadmissible, meaning that you cannot enter the United States, or even if you enter, you cannot be made a green card holder. Okay, so diseases like tuberculosis, ribello. Did I say the right name? I need to pull up the the list of the diseases against which you're supposed to be vaccinated. But I pulled it up. I reviewed it this morning, but for some reason I lost it. I'll try to pull it up again. But essentially, you should go to the civil surgeon. So you put in your zip code, and then you find a civil surgeon in your area or in your county or in your district or in your state. And these people have been designated by the USCIS to actually perform the medical examination for purposes of adjustment of status or becoming a green card holder. And so when you go to these people, normally the rule was that once they date it, so the medical doctor will date, okay, so you came for the exam, let's say December, let's say 10th, 2021. You see, the 60-day rule meant that your medical records should not be dated 60 days before you file your application for the immigration benefit. So if your civil surgeon dated December 10, 2021, I'm sorry, and then you subsequently apply and the date of your application is April 2022, your I693, which is the medical exam and vaccination record, will be invalid because it's been more than 60 days since the medical exam took place. Okay, but now that rule has been waived because, of course, COVID. Everybody is using COVID so COVID has its both good and bad sides, right? It's very helpful. The thing is that with the medical records, once you qualify for the 60-day rule, meaning that you submit your underlying immigration petition within 60 days of the doctor's signature, then the I693 form will retain its evidentiary value for 2 years. So it's valid for 2 years. Okay, so you do the exam December 10, 2021. USCIS will find that it's good evidence that you are admissible under health grounds up until December 10th, 2023. Okay. And so any time beyond that, then it loses its evidentiary value and it becomes useless or worthless. So within that time, they need to make sure they've adjudicated it. But now they've done away with the 60-day rule, so you don't need to. So even if you, let's say you did the medical examination December 10th, 2021, and your application, your adjustment, your adjustment your adjustment application, hold on, so it should be dated no more than 60 days before you file. Okay, so and your adjustment application is even dated, let's say March or April or June 2022, then you should be fine according to this rule. Okay, so let's read here. So in general, those applying for immigration benefits while in the US must use Form I693, as we've discussed, to show they are free from any conditions that would render them inadmissible under the health-related grounds. Inadmissibility, let me pull it up. INA section 2126. Interesting. I've just been working with a client on well, actually a number of clients on this grounds of inadmissibility. So I have the statute, the quotes in my head, for that reason. Guys, drop me your comments. I will be with you soon. I don't know why this pulled up. Okay. Let me not use this one. Let me see. Yeah, okay. Yeah, INA section 212. Beautiful. I pulled it up. So let's look at some of the diseases. So health grounds. A person who seeks admission as an immigrant or who seeks adjustment of status and who has failed to present documentation of having received vaccination against vaccine preventable diseases, which shall include at least the following diseases. And we have mumps, measles, we have rubella, polio, tetanus, diphtheria, diphtheria toxoids, pertussis, influenza type B, and hepatitis B, and any other vaccinations against vaccine preventable diseases recommended by. Okay, yeah. Okay, so those are the things you're supposed to be vaccinated against. Yeah, so that was just by the way, just to give you guys a little bit of the background. Let me scroll. I think we're here. Okay, so currently USCIS, what I discussed with you, considers a completed Form I693 to retain its evidentiary value for 2 years after the date the civil surgeon signed, as long as the date of the civil surgeon's signature is no more than 60 days before the applicant files the application. Okay, that's underlying the immigration benefits. Again, as I explained to you, if the civil surgeon signs December 10, 2021, then the latest time that you should actually file your application should be 60 days from then. So that should be what, January 10th, then February 10th, 2022. Okay, so before February 10th, 2022 is the latest time you should actually file the application for the underlying immigration benefit. Okay, so let me scroll down. Guys, drop me your comments. I don't see no comments here. Are you guys, if you don't feel like, talking, just drop me the emojis. It's Friday. Okay, right here. Okay, yeah. So due to the COVID delays, USCIS has experienced, yes, there's a lot of delays in aspects of the operations, and applicants have difficulties. Exactly. People are having difficulty even trying to get a medical exam completed, because the problem is that the civil surgeons are also backed up. And yeah, I sometimes have people calling me, okay, where can I go do a medical exam? Because, sometimes they are booked 6 weeks out, 2 months out. And so these will cause issues, okay? Because if your application has already been submitted a month ago, for example, and you need this, and they tell you they are booked 2 months away, that means by the time it comes back, it will be 3 months late, and it will be invalid because there's the 60-day rule. So it's waiving that 60-day rule. So the temporary waiver, when is this temporary waiver effective? So it's a temporary waiver, guys. Note that it's not perpetual. So it's effective from December 9th, 2021. Today is December 10th. So from yesterday, and it will be in effect until September 30th, 2022. So next year, September. And then they will reassess to see if they still need to extend it, or, just revert to what it was, to the 60-day rule. That will depend. Okay. So that's it. That's for the I693. And now we're going to be talking about, this is really good because it's really a nightmare. What happens is that people will go for interviews, and then they find that, okay, well, your application is dated maybe 4 months ago, and then your medical exam record was dated 90 days after the date of the application, and so it's no longer valid. And then people, the USCIS has to now issue what's known as the RFE, request for evidence, requesting an updated medical records, a new copy of medical records. And it's just increasing the backlogs, because now they have to wait until those medical records come in, and things may not have changed. It's really just a rule. And most of the time, if, whether the person's medical records is dated 65 days after the underlying application, or 70 days, normally nothing substantial would have changed. So they find that it's just really an unnecessary clog. It's just really clogging the system, and it doesn't really serve much purpose during this COVID backed up times. So yes, it's a good riddance, temporary good riddance until September 2022. So take advantage. And then, okay, so now let's move on to the next thing. We're going to be talking about the next thing, which is the COVID update. Okay, what is the COVID update? Let me share my screen on that, and then we will call it a day. Guys, I hope you guys are enjoying the video and benefiting from the insightful, updates that I'm sharing. Don't forget to like the page, subscribe, share with your friends. You don't know who could be searching for an immigration attorney. Okay. Okay, yeah, perfect. I found it right here. So the COVID pointers, let me open, because it's just the first part of this I want to ask to discuss. This is quite burdensome. So for the first part of today's news, it's good news. And this latter part is not so good news. It's quite burdensome. So the latest updates given by the CDC, is that they announced that. So on December, they announced this on December 2nd, which was exactly a week ago, maybe a week and a day ago, that if you are 2 years old and above and you are traveling to the US, regardless of your vaccination status, whether you have been vaccinated against COVID or not, or regardless again of citizenship, you will be required. So everybody who's above 2 years old, everybody, citizens, non-citizens, immigrants, non-immigrants, visitors, businessmen, who, if you are 3 years old, if you are above 2 years old to 99 or 150 years old, they don't care whether you've taken the COVID vaccine or not. You will be required to take a COVID-19 test, the viral test, that will show a negative result to the airline no more than 1 day before you board your flight. Okay. And the effective date of this requirement was on December 6th, which was Monday, Tuesday? Well, this week. Well, it's currently in effect. So now if you're going to if you're going to board your flight, you need to make sure that you have a COVID test that shows that you are negative. And the reason why this is news, December 6th was on Monday. Yes, it was on Monday. And the reason why this is new or it's an update, of course, even in the past, since COVID came, you needed to submit a test showing you're negative. But before December 6th, what was happening was that you just needed to submit a test that was done 3 days. Well, that was done within 3 days of your boarding a flight. But now it's just 1 day. So it gives travelers a very short time within which to get the COVID test. So if you do the test, your test should be done within 24 hours before you board the flight. So this is really burdensome, because that means that the people doing the tests have to have a very quick turnaround time, because it's no longer good if you do the test 3 days ago, and then you get the results and it's reflecting your COVID state 3 days ago. They want it within 24 hours. No more than a day before boarding the flight. So take note, it's effective, already in effect from Monday. So those, and again, the other part of this is that if you've recently recovered from COVID, and they've defined what it means to recently have recovered from COVID, it means that you had COVID within the last 90 days before you were coming to the US. So if you had COVID, let's say, we're in December, okay? If you had COVID in August, January, February, March, April, May, June, July, August, September, October, November, okay. So let's say August. If you had COVID from August, then this requirement will not apply to you, because it's been more than 90 days since you recovered. If we say recently recovered, it means people who have had COVID within the last 90 days. So that would mean October, November, December, okay, around the time. And if you've recently had COVID, meaning you've had COVID within the last 3 months of your intended travel, you would need specific documents. What you're going to need is that so with your travel documents, you need to submit evidence or documentation of your recovery alongside the letter from your doctor, okay, your licensed healthcare provider or public health official, that will state that you have been cleared for travel. Okay, and then so again, what I said, the positive COVID test results should be from a sample taken no more than 90 days before the flight's departure to the US. So if you had COVID 120 days before your intended travel, this second part of the documentation, demonstrating that you have recovered and a letter from your healthcare provider is not necessary. You simply need, a COVID viral test result that is negative. And that has been done within the last 24 hours, no more than 1 day before you board your flight. And then you should be good with that. Okay, so guys, that's all for today. Just bringing you the latest scoop in US immigration. I hope you guys had a wonderful time with me discussing, these new requirements and everything else. I will see you guys hopefully next week. And if you need my help with any US immigration problem, don't forget to call me 802-78-00564, representing immigrants around the US, all 50 states and around the world as well. You can call us, or in fact, better still, you can just book a consultation directly. It's always linked in the description box caption. Just go ahead and book, because sometimes we get overwhelmed with calls and we might not be able to respond to everybody. We're not deliberately ignoring you, but we just don't have the capacity to answer everybody at the same time if there's a lot of people who are calling at the same time. Okay, so guys, have a wonderful rest of your day, and I hope you guys have a wonderful and a fabulous weekend. Please take care, be safe. I'll see you guys next week. Okay, bye.